the first trimester ultrasound is the most accurate way to date a pregnancy. So why doesn't the FDA require an in-person visit where a woman could receive an ultrasound? You cannot have an ultrasound to check for a topic during a Zoom or a chat visit. When I did my residency in OBGYN, it would have been considered malpractice to prescribe risky chemical abortion drugs without a physician's evaluation and ultrasound. I have news for you. This still constitutes medical malpractice, regardless of what the FDA says. Their actions represent reckless disregard for women's health and safety, plain and simple. And I'll finish with one more story with a woman who I'll call Rhonda. She recalled our pregnancy decision line. Rhonda had taken the abortion drugs, and she told the nurse that she spoke to that after she aborted, she tried to flush the baby down the toilet, but it was too big, and she didn't know what to do. Rhonda's story is sadly not unique. Without a physical exam and evaluation and an ultrasound, the abortion trimester need a surgical procedure to complete the abortion. The FDA has left women and girls to fend for themselves, has put their health and safety in danger, and has left a trail of trauma and suffering. Our women and girls deserve better. The FDA needs to make this right and reinstate safety standards. Thank you for your attention.
Thank you, Dr. Christensen, for that powerful speech and for sharing the testimonies of those patients, of those women. We need to believe these doctors when they're telling us the dangers of these chemical abortion drugs. And we need to believe these women when they tell us how they have been harmed. Don't we want the highest standards for women? Don't we want the best for women in this country? Please join me in cheering. Women's health matters. Women's health matters. Women's health matters. Women's health matters. Today is a day that is somber. Today's case is critical. There is a sense of urgency today. For the sake of women in this country, we need to believe these women when they tell us their stories. We're going to continue on with the rally now as I welcome up to the stage Joseph Coe, who serves as the Director of Public Policy at Family Policy Alliance, where he leads FPA's policy strategy, provides policy and legislative expertise, and drafts and advocates for pro-family legislation at the state and federal levels. He has worked extensively on FPA's Help Not Harm, After Roe, Let Parents Parent, and Save Girls sports campaigns, collaborating with legislators and state and national allies to enact policies that protect women's safety and opportunities, vulnerable children and families' parental rights, and born and unborn children. He also regularly hosts FPA's podcasts, the So-Called Report podcast, to inform and generate action amongst thousands of listeners and viewers. He is a U.S. Army veteran of the 10th Mountain Division Light Infantry, where he served as an officer in the 1st Brigade Combat Team. We thank him for his service, and we thank him for being here today. Welcome, Joseph Coe.
Thank you, Catherine. Thank you to ADF, and thanks to all of you for being here. Good morning. This is a great day. This is a great day for America and for the pro-life movement. I am so honored to be here. I'm representing Family Policy Alliance, as Catherine said. I serve there as a lawyer and the Director of Public Policy. FPA is a national organization dedicated to seeing policies that support and honor families, including protecting mothers, enacted around our country and here in the federal government. FPA is also blessed to facilitate a network of what we call Family Policy Councils, or FPCs. These are state-specific organizations that advocate for socially conservative and pro-family policies at the state level, including the protection of pregnant women. Some of them are here today. You're going to hear from them later. We are forever proud to stand alongside and support them in the noble effort to protect mothers and vulnerable women. We were also proud to sign on to an amicus brief in this case, drafted by one of those FPCs. So if you're not already connected with your state Family Policy Council, I encourage you to do so by going to familypolicyalliance.com/allies. Now, 2 years ago, we rejoiced with all of you at the long overdue justice that was done when Roe versus Wade was finally overturned. FPA had already begun preparing for the inevitable end of Roe by launching our #AfterRoe campaign. This campaign continues to offer policy solutions to better help our state and federal laws reflect the value of unborn life and protect mothers. And it's for that exact cause that we are so proud to be here with you today. FPA and our state allies believe that pregnant women deserve ongoing care from doctors when taking high-risk drugs. We know that 1 in 25 women who take abortion drugs will end up in the emergency room. The FDA's own warning label for this drug regimen admits that. And a gamble like that is what any reasonable person would call high risk. And by removing those required in-person visits for mothers taking abortion drugs, visits which are necessary for checking for ectopic pregnancies before even prescribing the drug, the FDA has effectively replaced those in-person visits with an emergency room visit. This endangerment of pregnant women by unelected deep state bureaucrats is entirely unacceptable. But pregnant women also deserve a government with their best interests at heart. The FDA has shown that it clearly does not. Because it acknowledged that statistic, thank you. Because it acknowledged that 1 in 25 statistic when it deregulated the drug. So we are all here today to ensure that great wrong is corrected. That is what you and I stand here to demand. Justice for the administrative state's betrayal of American women. Now, government of the people, by the people, and for the people requires that we not rest until the administrative state is held accountable and follows their own science and acts in the best interests of vulnerable Americans. We at FPA are so proud to stand shoulder to shoulder, arm in arm with you in the noble effort to forge that more perfect union that partners with its citizens to protect them rather than recklessly endanger them. So thank you. God bless you. I pray we would God bless the court today. Pray for the justices. Pray for the lawyers. Pray for this case. Thank you all.
Thank you, Joseph. We're going to keep this rally going. I'm delighted to welcome up Sarah Perry. Sarah Perry is a senior legal fellow in the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation and former senior counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education. She's appeared in both national and international media outlets, including the Associated Press, BBC World News, Fox News, The Washington Times, NPR, and the New York Times. And now she's here this morning to speak with us today, Sarah Perry.
Good morning. My name is Sarah Perry. I'm a senior legal fellow at the Heritage Foundation. And let me tell you something. This case is not about abortion access. The Supreme Court is not going to decide whether or not the abortion pill is available now or 10 years from now. And if you believe this case is about abortion, you've been lied to. Do not believe the hype. What this case is about is that every federal agency follow the law. Unelected bureaucrats that make decisions impacting the lives of everyone in America must adhere to the rule of law, even the FDA, especially the FDA. That's because the FDA is responsible for protecting the health of every American in the country. It has to ensure the safety and the efficacy and security of the cosmetics we apply, the drugs we take, the medical devices we use, the food that we eat. But in removing critical safeguards on the use of the abortion pill without following federal law, the law that governs all regulation making in the country, the FDA didn't just let down American girls and women, it imperiled their safety. that the FDA violated. It also violated the Food, Drug, and Cosmetic Act, which requires that the FDA determine a drug is safe as used by consumers, which means the use of evidence showing the drug is safe and effective for minor populations of girls, which is evidence it did not have. When it first approved the drug in the year 2000, it used a fast-track process to get the drug to market. How? It classified pregnancy as a serious or life-threatening illness. Now, that doesn't pass the straight-face test, but the FDA recognized the dangers of mifeprex even then and issued safety regulations for its use and distribution that limited a woman's exposure to the dangers, including how she could get the pill, what medical exams were necessary, and how far along she could be in her pregnancy in order to use it. The FDA knew that mifeprex carries common side effects: fever, nausea, vomiting, chills, dizziness, along with cramping and bleeding that can last for weeks. It knew that mifeprex is associated with side effects like hemorrhaging, immune system inhibition, and septic shock. It is linked to 32 deaths, thousands of adverse events, often resulting in ER visits, and more than 500 life-threatening complications. And because the FDA decided to make reporting complications voluntary and optional, that number of complications is even higher. Women should be under medical supervision when taking these drugs, but they are sent chemical abortion drugs in the mail and left to fend for themselves. Why then did the FDA drop its safety regulations in 2016 and 2021? Why allow them to be dispensed through the mail without any physical examination to diagnose gestational age? Why extend mifeprex as used from 7 to 10 weeks? Why did it say ultrasounds not required? Why allow healthcare workers other than doctors to administer it? Why require doctors no longer to report complications? Why did they make the drug less safe? Federal agencies have to make decisions that are reasonable and reasonably explained, decisions supported by law and evidence. But the FDA's decision to remove important safety protocols was arbitrary, capricious, and an abuse of its agency discretion. No federal agency is above the law, not the DOJ, not HHS, not education, and certainly not the FDA. The FDA has a duty to protect the health of every American here, including the women on the other side of this partition.